Hello, this is Harry Margolis, and this is the first lesson in our course on Estate Planning 101. Today we will be talking about the basics of estate planning, which I guess is a good place to start on the first program. So the main estate planning documents that we're going to talk about today, and we'll be talking about in more depth in other lessons, are the durable power of attorney, the healthcare proxy, the HIPAA release, the revocable trust, and the will. And you'll see we put the will last, even though many people think of that as the most important document. And we put the durable power of attorney first, which is what I think is the most important document. And another interesting distinction between all these documents is that the first ones all talk about what happens during your life, and the will talks about what happens after you die, and the trust, which we'll talk about briefly, really does both. It acts while you're alive and after you die. Most people think about estate planning as just what happens to their stuff when they die, but planning for life is even more important. And a power of attorney allows someone else, your agent or attorney in fact, to step in for you if you ever become incapacitated. They can make financial decisions for you, pay your bills, deal with your investments, and they can also make legal decisions, sign contracts, end a lease, sell your house, whatever needs to be done in the event of your incapacity. The healthcare proxy is similar to the durable power of attorney in that it's for your life and appoints an agent to stand in for you if you're incapacitated and can't make decisions for yourself. But the healthcare agent makes healthcare decisions for you. And what we would hope is that the healthcare agent also knows what you would want. So the healthcare agent, you need to talk to your healthcare agent about what your values are and what your wishes are should you become ill. The next most important document is the HIPAA release. And HIPAA is the law that says that doctors and other medical people and institutions can't talk to anyone about you without your permission. It's basically a privacy law. And it can sometimes get in the way because if you are incapacitated, you would want your family members to be able to communicate with healthcare professionals, and sometimes they won't talk to your family members, either because they really are concerned about breaking your privacy, or because they don't want to be bothered. They're too busy, and often they don't get important information that they need. So it's important to have a HIPAA release as well, which permits whoever you name on it access to your medical records. As I said, it prevents the healthcare provider from stonewalling. And where the healthcare proxy, on the healthcare proxy, can only name a single agent at a time, the HIPAA release, you can name whoever you would want. So you can name your spouse, all of your children perhaps, anybody who you think may need to be communicated at some point with healthcare providers, even though they won't be the decision maker. Only your healthcare agent would be the decision maker. The will is the last document we're going to talk about today, except for the trust. Now we're stepping into the realm of what happens after you pass away. And one thing that's interesting is while the will says who will get your stuff when you die, often a lot of your stuff passes to others because you've named them already as beneficiaries on your accounts, or beneficiaries on a retirement plan, or beneficiaries on your life insurance, and the will doesn't affect those. So, but the will is still important because it appoints your personal representative or executor or executrix, if the person is a woman, to handle things, be in charge to make sure everything gets taken care of when you pass away. And we'll talk a lot more about this in our lesson on wills. And then they're responsible for distributing what doesn't have a named beneficiary, as well as your real estate if you don't have a joint owner, and your tangible assets, which is everything you own. And if you don't have a will, then you will have died what's called intestate, and the state has its rules of intestacy, which says who will get your stuff, and it allows anyone to apply to become your personal representative. But so the rules of intestacy may work if you have kind of a standard family where you were married once and you had 3 perfect children and everybody gets along, it may work just fine. But if that's not you, then it's not going to work for you. So the trust really is a hybrid. So trust manages whatever assets you place in, you title in the name of the trust. And again, we'll talk more in our lesson about trusts, about how they work and what they are. But they're very good vehicles for managing your assets in the event of incapacity. They help avoid probate, and they can really do whatever you want. I often call them the Swiss Army knife of estate planning because they're extremely flexible. So that's your basics. You're ready to go. Here's some places you can get more information. We have a lot of information on our law firm website at margolis.com, including podcasts, other webinar recordings, legal guides, and handouts. And at askharry.info, I will answer any question you post there about estate planning. Thank you for joining us today.